Thank you. So this is a favorite topic for me. My name is Jen Lee. I am a bankruptcy attorney in Northern California. And so this is a really fun topic for me to talk about. So thank you, CEB, for asking me to do this. I think all lawyers should get paid. I'm sure that's a popular sentiment in the room. So I'm going to jump right in. If you do have questions, again, feel free to put them in the chat box. I have instructed the moderators that we can do questions at the end of each section instead of waiting to the very end, if that makes more sense. So let's talk about initial consultations. So our first section is on initial consultations. And the first thing that always comes to mind with attorneys is I have to do a free consult. So I kind of wanted to go through a little bit of the free consult versus the paid consult. You don't have to do a free consult. However, for marketing purposes, or if that's your marketing, you can do a free consultation. If you want to do a paid consult, do a paid consult. Don't be afraid to do that. So there are ways to do both of them. You can market yourself as some kind of session or a package or something like that to do a paid consult. No matter which session you do, if you do a free consult or a paid consult or some type of applying it to the retainer, make sure you have an agreement for that initial consultation. Even if it's free, have a written agreement saying, this is what your free consult consists of. Here's what the next steps are if you want to hire us, that kind of thing. So your representation agreement for initial consults can be for free or for paid. Personally, mine is a paid consult, and I have a 1.5 page agreement that basically says this agreement covers this initial consultation. This is the cost. This is what it includes. Any additional representation will be under a separate fee agreement. So I'm very clear to outline exactly what the agreement covers and what the session covers. Also, when you get through with your consult, you should have a script for the next stage of your representation. And I know that sounds very salesy and lawyers don't do sales and yada, yada, yada. But you should have a way to transition from either a free or a paid consult into how you're going to charge for the next stage of representation. And I highly encourage you to practice that. So that's a very smooth transition, because if you want to get paid, you have to be able to confidently express your fees. No matter if it's hourly, if it's contingency, if it's a flat fee, and we're going to go through all of those different types of fee agreements, but be confident in how you explain how someone can hire you, because getting paid, 95% of it is you being able to explain the value of what you're providing. So are there any questions on that initial part? Because it's a really short section, but I wanted to make sure that people have fee agreements for their initial consultations and not just, this is a quick 15-minute discussion and I may or may not take your case. More of a actual consult where you're talking through the problem with the client and figuring out whether it's a good case or a bad case and that kind of thing.
We don't have any questions right now,
Okay.
But if folks do, they can just chat them in and we'll get to it later in your next section.
Got it. So we are going on to fee arrangements. So this is the meat of this. We're going to go through a lot of rules for how these things are done, but fee arrangements that are most common these days. Contingency fees, you usually will find contingency fees in things like personal injury or often in fee shifting practice areas like veterans benefits. I've done veterans benefits work, and the contingency fees are based on a successful appeal and the VA pays you. And then Social Security, things like that. So those are the types of things that could be a contingency. The bar does have a few areas that are not allowed to be contingency. For example, I believe in family law on Rule 1.5 of the Rules for Professional Conduct has that you can't contingent on the amount that you get in a settlement or the amount of child support or that kind of thing. And I also believe the contingent fees under Rule 1.5C2 say that you can't use a contingency fee for representing a defendant in a criminal case. So there are a couple of practice areas where contingency doesn't work very well and not allowed. Probably the most highly controversial fee arrangement is flat fee. And I am biased. I will say I'm biased because I think flat fees are very, very powerful and actually improve profitability in law firms. So if you think that I'm kind of leaning that way, you're probably right. Flat fees are very powerful, but they also can be very difficult to do because most attorneys base their fees on how much time they think something is going to take them. A lot of times in litigation, it's hard to figure out how much time something is going to take. So I often encourage attorneys to value the fee differently than their time. Now, the state bar does have about 13 criteria that are used to determine whether a fee was unconscionable or unreasonable. So they're in the state bar rules. So make sure that you know what those are and that you're following those. But I encourage people to try to figure out flat fees. So in bankruptcy work, it's fairly standard to do flat fees on the debtor side of things. I know in family law, it's not quite as common because you never know what the other side's going to do. So it's hard to predict costs and trial and if they're going to go into all kinds of discovery disputes and that kind of thing. So some practice areas are much more easy to do with a flat fee. There are a lot of business attorneys who will do contract reviews for flat fees and things like that. So one thing I want people to keep in mind when they're doing flat fees is you don't have to quote the same flat fee for everything. I have often seen business attorneys who have like a 20-page contract, and of course that's going to take, much more expertise and time to go through than a 2-page contract. It's okay to quote different flat fees for those things. The most important thing with flat fees is to outline the scope of your representation and limit it so that if you go beyond that, you have another flat fee. So, for example, when I'm doing bankruptcy work, sometimes I will have someone come in and we're not sure if bankruptcy is going to be the right thing. So I'll quote a flat fee to do an analysis. And then from there, another flat fee once we figure out what that next step is going to be. And that's also called milestone, but it's still a flat fee arrangement. Hourly is probably the most common for attorneys. That's the traditional business model, the traditional way of practicing law. And if you couldn't tell, I'm not very traditional. So hourly is my least favorite way of doing my fees and my least favorite way of attorneys doing their fees. And some of the reason for that is because I think there's a lot of innovation out there. There are a lot of attorneys doing some cool things, especially since we're all being required to work remotely with clients now, that I think the hourly business model probably could use some limiting. But hourly is it's still the same thing. You still have to outline what your scope of services is, what your hourly rate is, all of those things, and keep track of all your time. For all of these fee arrangements, you should be keeping track of your time. I know a lot of people think if I do a flat fee, I'm doing it on a flat fee so I don't have to keep track of my time. From a law firm profitability standpoint, you should still keep track of your time. Also, there are some cases where if you are going to get the other side to pay for your fees, that you'll have to have support for the amount that you charged. And a lot of times they look at hourly fees. They haven't quite caught up to the 21st century sometimes. After hourly, milestone. So milestone is similar to what I said a few minutes ago, where I have a flat fee for the first part of a case, a second flat fee for the next part, and then possibly a third or fourth. This also happens, I've seen it happen in family law quite a bit, where they do, if we settle the case, then it's going to be a flat fee of this. If we go to trial, it's going to be this. And then before each part of the case, it's a new milestone flat fee. And some attorneys do publish their milestone fee schedules. Some don't. It's up to you. But there are ways to structure these things so that you're not losing money on every case. Because I think that's what most attorneys are afraid of is, am I going to lose money if I don't bill for every email that goes out? And finally, hybrid. So a hybrid could be part contingency, part flat fee, part any of these different things. I've had cases where I've done the flat fee for the bankruptcy part and then switched it into hourly after we got through the initial part and we're going into more litigation. So you can do hybrid fee agreements as well. The important part with all these fee agreements, we're going to go through all the rules for how you have to explain this to the client and what you need to include in your fee agreements. But most of the important part is that the client understands how fees and expenses are going to work and what they're going to be on the hook for. Because even someone who explains it completely to a client, because I've had this happen to me, later they'll come back and say, I didn't realize I had to pay X amount of dollars for success at before trial type thing. So the fee agreement terms and requirements. So we're getting into business and professions code. 6147 to 6148 has a lot of the rules for business and professions code, what has to be in a fee agreement. And when you're drafting your fee agreements, make sure that you're including all of the details of what your representation is. Under business code 6147, you have to have them sign it, obviously, provide a duplicate copy of the contract to them, and it should be in writing. And we're going to talk about what should be in writing on the next screen, why it should be in writing, but a contingency fee agreement should always be in writing, and it should always include what the fee is. If you're doing a multi-stage contingency fee, I've seen some 30% of recovery if we don't go to trial, if we settle, 35% if we get to pre-hearing, 40% if we get to trial type thing. So make sure that's all listed out in your fee agreement, and that it's very clear to the client, especially for contingency and anything you're doing that's not normal hourly type billing. Under Rule 6148, if the fee is going to exceed $1,000, it must be in writing. There are some exceptions to that, and I'm going to go through that in a second here. But the flat fees, when it comes to refundable versus earned, is an interesting area when they changed our rules about 18 months ago. And there's some magic words language in Rule 1.15 that talks about when funds can be accepted on a flat fee and when they can be moved into the operating account or taken directly into the operating account. You do have to advise the client that they have the right to require the flat fee be deposited into an identified trust account until the fee is earned. And the reason why we're calling these magic words, so I highly encourage you to look at Rule 1.15, and it's under B12. Because if you have those magic words in your fee agreement, that's supposed to be advising the client that you're putting it into your operating account for a flat fee. The written requirement, fees exceeding $1,000 must be in writing. Make sure that, and I would encourage you honestly to have every fee agreement you do in writing, even if it's less than $1,000, if you're doing $500, if you're doing a $200 half-hour phone call, I would encourage it all to be in writing because you won't go wrong having extra documentation for things. Because I have had disputes on fees before, and I won the dispute because I had everything in writing and documented. Let's see here. So, and this leads into fee disputes and arbitration clauses. So in the materials, there is a huge file of the state bar fee agreements. There's 3 of them in there. There's red line versions. There's descriptions in there. Please use those. You can substitute clauses in. You can take things out. They have some optional clauses that are in there, but they're really good for having the right language in your fee agreements. And a lot of the legal malpractice attorneys recommend that you use the mandatory fee arbitration clauses that are in those fee agreements. And basically, when you put that into your fee agreement, it lets, first of all, it lets the client know that your fees will be arbitrated if there's a dispute about them. And I also included in the materials a notice of client's right to fee arbitration. So if you choose to sue a client for some reason for fees, and they you give them the notice of client's right to fee arbitration. It's a 1-page form. Very useful for settling disputes for fees. So if you find that mandatory fee arbitration clause in the materials, I would use that. I use that in all my fee agreements too, because that often can settle dispute for much cheaper than actually suing on it or any kind of other legal remedy on it. Your fee agreements also have to include malpractice insurance disclosure if you do not have malpractice. So the rule says under 1.4.2a that you have to disclose if you do not have professional liability insurance. If you do have it, technically you don't have to disclose it that you do have it, because it's assumed that you have it if you don't disclose it. But the language in the sample fee agreements have where you can put in, I do have or I don't have malpractice insurance. If you don't have malpractice insurance, I encourage you to get it, but you do have to disclose it in writing if you don't have it. There are a couple of exceptions to this rule. If the engagement's going to be less than 4 hours, if it's an emergency rendering of legal services for some reason that happens to occur because of an emergency at that time, if you are a government or in-house counsel and you're providing services under that government or in-house counsel position, or if the client was previously informed that you don't have malpractice insurance, you do not have to advise them again under 1.4.2a. Do we have any questions so far, Talia or Kelly?
Yeah. So when you say that you should have fee agreements in writing, are you also saying that these agreements should be signed by the client and the attorney?
Yes.
And the other question is, how do you get the client to sign before doing any work? Is it during the initial consultation?
That's a good question. So the way I do it in my practice is we do okay, I'm going to preface this by saying normally when the world is normal, and the world is not normal right now, but normally what I do is we sit down and we say, okay, this is the agreement for today's discussion. Here's what it includes, and then sign it. And then we go into the discussion. Under current situation, I send them a DocuSign. I use HelloSign ahead of time and say, here's what our agreement's going to cover, and have them send it back to me before their appointment along with their payment. So yes, I do have them sign it ahead of time. And then if they're going to continue with representation, we close out the consultation with our next steps, and I send them a new document through HelloSign and a link to pay.
Great. Next question is, if someone is coming in for consulting on an as-needed basis and they are paying by the hour, do you have to do a consulting retainer once they exceed 1,000?
So yes. So the rule says that once you've exceeded that 4 hours, you're supposed to disclose that when you've known that you've exceeded that 4 hours.
Can you use DocuSign for obtaining the client's signature?
Yes. So it's an interesting question, especially what's going on these days, but California allows DocuSign for agreements, fee agreements, things like that. In federal court, in bankruptcy court, we could not take DocuSign for pleadings that were filed in court. However, they've temporarily suspended that rule of having to have wet signatures, and they've changed it to allowing DocuSign or HelloSign. So yes, you can use DocuSign.
And how would you include reimbursable expenses for outside services when the amount is unknown?
So usually, and if you look at the sample fee agreements, they do have an expense clause in there that says if you're going to front the expenses, usually you're going to know somewhat of the expenses that are going to be needed. If it's a filing fee, if it's something that's really unknown, I would clear that with the client and have them pay them once you know what that expense is going to be. Because that's not going into your fees, it's going into the expense of the case.
Mm-hmm. And this is just a general statement. For those of you who are on right now, we will be sending out the PowerPoint deck and the resources after the webinar. We'll send them out within the hour, so by 2 p.m. So we're getting a lot of questions on that.
Well, it's also, it's difficult sometimes. Like there's some things that pop out and you're like, oh, I should ask a question about that. And then you forget and the slides have moved. So I get it.
We actually have a question that is related to your earlier slide on initial consultation.
Yep.
Does it matter if it's by phone or should it be in person?
Doesn't matter. I do most of mine by phone or Zoom.
Okay. And also folks are asking if you will have sample fee agreements or
Yes.
you'll provide sample fee agreements. Yes.
Yep.
And I assume these will all be emailed to attendees afterwards.
Correct. Yeah, I have about 6 packets of materials that go with this. The rules and then the sample fee agreements they look very long, but if you'll go through, it actually looks like there's clauses, optional clauses, and then comments by the state bar on when to use things and that kind of thing.
Great. And a few other questions coming. If the client refuses to pay the expenses, am I liable to the vendor?
Probably. So generally the vendors do a contract with the attorney. there are ways to get around that. I've had some vendors or some outside counsel or expert witnesses sign the agreement directly with the client if necessary. But usually, and when I do expert witness with civil litigation attorneys, I bill the attorney because I want them on the hook for it and not their client.
Mm-hmm. And lastly, before we go on to the next section, you mentioned a program for DocuSign. What is the name of it?
Oh, okay. Sorry. DocuSign is like the industry standard. Probably most real estate closings use DocuSign. I use HelloSign because I'm cheap. Well, not super cheap, but I think it does the job and it's less expensive than DocuSign. Also, there is Adobe Sign out there. If you have an Adobe monthly subscription account, it's actually included with Adobe. So you may have Adobe Sign already as part of your software package.
Okay. And do we have time to take one more before we move
Sure.
on?
Mm-hmm.
Okay. Can you discuss agreements in other languages?
Interesting. I don't, so the client has to understand the agreement. So if that means you need to draft the agreement in another language, it still have the same things in it. I guess, does that answer? I mean, if it can be in other languages, that's fine, but the client has to understand it. Like I won't have a client sign an English fee agreement if they only speak Spanish.
Mm-hmm.
Okay.
Thanks, Jen.
Anything else? Okay. So now we're going on to my least favorite topic in the world is trust accounting. So there are firms out there. I've been on panels with attorneys who don't use trust accounts. Everything is a flat fee, earned upon receipt type agreement. You can do that. Again, you need those magic words I talked about. But a trust account is basically funds held for the benefit of the client. And where I see most things go wrong with trust accounting, I do a lot of bankruptcy and debt work with attorneys and law firms. And I see pretty sloppy accounting of how the funds are held in that trust account. So if you're going to use a trust account because you have to for the types of cases that you're doing, please make sure that you are using the trust account appropriately. Most hourly cases, you're going to have to use a trust account to take fees up front and bill against. And if you have flat fee cases, there are a couple different ways to do it. So flat fee, you could put it into trust, then you don't need any magic words in your fee agreement. You just bill against it as agreed in your fee agreement. So let me say, in 30 days, I earn this. I know with estate planning attorneys, I've met a couple that do, 50% is earned when I draft the documents and 50% is earned when you come in and sign the documents. So things like that. So if you're holding funds for the benefit of the client, you do need to have a trust account. This is also true if you're holding, for example, we were talking about expenses earlier, and this is most common in my practice with bankruptcy fees. You should be including your court filing fees are in the fee agreement that say you're going to pay the attorney $3,000 plus a court filing fee of $335. If I put that $2,000 into my operating account because I have the magic language in my fee agreement that says I can do that, and that's fine, but that $335 court filing fee should go into trust. So I think a lot of attorneys get a little sideways on that. Trust account best practices. So if you have a trust account, use a bookkeeper. Get a bookkeeper who knows how lawyer trust accounts work, because it is really frustrating if I have someone I'm working with and we find out that their trust account, they have no records. They don't know the funds in the account, who they belong to. And honestly, as lawyers, we're probably not the best at bookkeeping. Otherwise, we'd be in a different profession. So use a professional. So just like you want a professional to come use your services for what you know, use a bookkeeper. If you don't want to use a bookkeeper because you're starting out brand new, you don't have any money, whatever the reason is. And I had a bookkeeper one time that was like $150 a month. It was the best money I ever spent. You have to reconcile your accounts regularly. You need to show down to the penny what's in the trust account and who it belongs to. So under the rules, so we're looking at 1.15 is the rule on what you have to put into the trust account. You can also have a small amount of money in the trust account to pay potential fees, bank charges, that kind of thing. I've usually heard about $100 is appropriate for that. So everything in the trust account should not be your money, except for maybe that small cushion of $100 or $50. And for record keeping, you want to maintain records and statements and a written ledger, and this doesn't have to be written like handwritten, you know, from Charles Dickens where he's sitting there writing in the ledger, but it has to be something in writing that you're able to track each client and how much is in there. So it should have the name of the client, the date, and the source of all the funds received, the payee and purpose of each disbursement, and then the current balance for each client that's in there. So your trust account should have a written ledger. QuickBooks, I know, has this set up pretty well if you set up your QuickBooks accounts appropriately. When you get your bank statements for your trust account, make sure you go through and make sure it matches to the penny what's supposed to be in there. And you should have an IOLTA account if you're doing any type of retainers, hourly work, even contingency agreements, because a lot of times if you're going to settle something, it's going to come into your trust and then you're going to disperse to the client and to your firm, however your agreement is set up. Earning fees from trust. So now we're getting into a little bit more of the practical of how do I get my money out of trust once I've earned it. You're supposed to withdraw funds from the trust account at the earliest reasonable time. Under the rules of professional conduct, it's 1.15C2 on there. And that means as soon as you have earned the fees, they should be taken out. You would be really surprised sometimes, I think, how some attorneys keep funds in there and just have it as an extra savings. And that's not how it works. You've commingled funds at that point, and it's a very large issue for the state bar. So if you've earned fees, take them out as soon as you've done the billing and shown that you've earned the fees, or you've completed the estate plan and now you've earned your 50% fees, or whatever your timeline is for earning fees. If the disputed fees, so if the client comes in and disputes your fees based on your bill, you're supposed to keep all disputed fees in trust until that dispute is resolved. So if a client comes back and disputes, funds are still in trust, then keep them there. And that doesn't work, so I'm going to put a little caveat in there. So for flat fees that you're earning upon receipt and you're using the magic language for, if a client comes back and disputes your flat fee, you need to be able to show what was reasonable, and that's the 13 criteria for reasonable fees. And if you have to refund something back to them, you better make sure you have enough in your operating account to be able to refund if it's disputed and they win. So if you're doing large flat fees, I would just be careful to keep a cushion if someone disputes your fees. So now my favorite topics: getting paid, how to get paid, how often, how you should accept fees, other forms of payment, and that kind of thing. I know billing is a sore spot for a lot of attorneys. You get to the end of the month and it seems like we rush through on the first or second of the month trying to get our bills out. But how often you bill should depend on the type of case you're doing. If you're doing hourly, probably once or twice a month. If you go longer than a month, then clients start to see larger and larger bills, and it's more of a client management issue. And your fee agreement should say how often you're going to bill. If I'm doing an hourly case, which is fairly rare, but I do have a couple of organizations I do hourly work for, and they have me on a twice a month billing schedule. So if you're doing hourly, I would say once or twice a month. Twice a month is kind of nice because then you've got your operating account is being replenished on a regular basis. And I'm a big fan of having money in my operating account. Flat fee. The nice thing about flat fees is generally there's no billing required. You don't have to send an invoice out each month to the client. However, here's my caveat. You should still track your time, because if that client comes back and disputes any work that was done, you can at least show how much time was spent in the case. Because if it's disputed and you have to go to arbitration, you want to be able to show how much work you did and how much time you spent on their case. So I know that's hard. People don't want to track their time, but just track your time. Contingency, you should be doing continuous time tracking. Do it contemporaneous with your case. Make sure you're updating your hours and your 0.1s or your 0.25s or whatever your billing increment is. because some fee agreements are based on a contingency or a flat or contingency or an hourly fee, depending on which one's less. I've seen that in some Fair Credit Reporting Act recovery or Federal Debt Collection Practices Act cases where it's a contingency of the recovery or the amount of time spent on the case, whichever one is less. So continuous time tracking for contingency is probably a really good idea, especially if you're going to try to shift fees to the other side. And then hybrid and milestone, it depends on what your fee agreement says. If you are doing it hourly to start with, or you are doing it contingency or flat fee, I would say no less than one time a month for any type of billing where you're expecting them to either replenish your trust account or pay your invoice as it comes out. Which leads us into the next thing is how are clients actually going to pay you? Please make it easy for them to pay you. There has been a lot of discussion over the last 20 years on accepting credit cards in law practices. And some people don't want to pay the 2% or the 2.9% or the 1.9%. Increase your fees to cover the cost. Don't say I'm going to charge you $1,000 plus a 2.9% service fee, because the service is really for you. And the reason I say that is because you're going to get paid a lot quicker if you allow credit cards and don't add on a service fee for it every time. And I'll give you an example. Right before I got on this webinar, I am working on a trademark and a licensing for myself. And I emailed my IP attorney and I said, okay, I'm ready to go, send me the bill for this. She shot over the bill with our case management system, and I paid it in 2 seconds. Before she could even draft an email to me to set up a call, she's like, oh, you already paid, because I could pay with a credit card, and it was easy. So make it easy for clients to pay you. There are a number of services out there for lawyers. Some practice management software services include the monthly fee as part of your practice management fee. I know mine's included as part of my online practice management system. So take credit cards unless, okay, let me qualify this. I'm a bankruptcy attorney. I can't take credit cards for bankruptcy fees. I take debit cards for bankruptcy fees unless it's a family member paying for it. But so if your industry has a reason why you can't take credit cards, then you wouldn't want to take a credit card for that type of fee. Along the same lines, ACH, most of the legal processing payment processors these days also have the option for ACH, which usually gets the money into your account quicker, but it depends on the processor. I've heard some are taking like 4 to 5 days where credit cards are going in within 2 days. So it really depends on your processor and talk to them. And then there's always personal checks. And I think I see this more with older generations where they still have checks, but you can take personal checks. Just be cautious. I did have a personal check bounce out of my trust account one time, and I had to go through an account for everything and replenish it and that kind of thing. That's why you want to keep a little bit of extra in your trust account. So if you have a client who you have a belief that their personal check isn't going to be good, like you're in bankruptcy work, then I would be more careful with personal checks. I've only ever had once in 10 years though. And then cash is always king. So if someone's going to pay you in cash, if it's, just be careful with how much cash you have sitting around and usually deposit it like you need to. And cashier's checks are money orders. So I probably see these more often than a lot of practice areas do because I'm in bankruptcy. And if someone needs a case filed really quickly, there's a foreclosure sale, then they have to bring me either cash or cashier's checks or money orders. And I would encourage you, if you take personal checks and cashier's checks or money orders, deposit them right away. I've had some attorneys say that they delay depositing things because they don't want to go to the bank. Find a bank that will do mobile deposit into your trust account because they are out there, and it's a fantastic service if you want to deposit things into either operating or trust, but my bank, you can do both. So make it easy for them to pay you, because the easier you make it, the more money you're going to make into your law firm. Are there any questions? Should we start with questions before I get into collection issues?
Yeah, we have quite a few questions. And some of them were for your previous section. Okay, so let's just start with that one. So when you were referring to trust accounts in your previous section, were you referring to interest on lawyer trust accounts?
Yes, IOLTA accounts, yes. Or IOLTAs, yeah.
Do you have a recommendation for time tracking software?
So there are a lot of them out there. Most practice management softwares include some time tracking. I use Practice Panther as my firm management. All my attorneys use it as well. I know Clio is pretty popular these days. Cloud-based ones are more popular than the local practice management softwares because of now what's going on with COVID-19. And there are some out there too. I'm trying to remember, like My Timekeeper, I think. It's a little app that you can use as a tracker just for you start and stop it as you need to track things. What I like about Clio and Practice Panther and the other softwares is you can link it directly into the matter, so you're not going in and having to update things constantly. It's time saver, pretty much.
And what are your thoughts on using Venmo as a form of payment?
Venmo is probably okay. So I would not recommend using PayPal. I know they didn't ask about PayPal. Venmo is fine because it's usually just a bank-to-bank transfer. I know PayPal owns Venmo now. The problem with PayPal and lawyers is if the client disputes the fees, you will lose with PayPal because you're not delivering a product. It's a service. And so as soon as you say that you didn't deliver the product, I've never heard of someone actually winning against PayPal for that. I also can't use PayPal as a bankruptcy attorney because they've excluded it from their terms. So I would not use PayPal, but Venmo, probably okay. Zelle is also probably okay. I would more likely recommend having a legal payment processor.
Mm-hmm. And how do you take credit card payments for an attorney-client trust account deposit?
Good question. So most of the legal payment processes are out there. So the two big ones are LawPay and LawCharge. And I use LawPay, although I do know the owner of LawCharge and it works very well too. So for LawPay, as an example, I have two links with them. One's a trust account and one's an operating account. And so when I want to deposit into my trust account, I send the client the link for the trust account. They deposit it in there. And then LawPay turns around on the first of the month and withdraws the processing fees from my operating account. So you're not mixing up funds and you're not taking the fees out of the money that's going into trust, because the amount that goes into trust should be the balance of the client's money, the full balance, not a discounted balance for the processing fee, which is the problem a lot of times with PayPal and other services. And you want to watch the terms of service too.
Jen, are you also, the next question is about Rocket Matter, which is a legal case management software. Are you familiar with that, and what's your opinion on that software?
I'm not as familiar with Rocket Matter. I know of it. And so every few years I try to go through and test them all out to see what's new and everything. I'm not as familiar, but I've heard good things about it. I don't think there's any reason to switch if you like it.
I'm also looking through the questions through chat. If you have a question, please use the Q&A icon, but we do have a few questions that came through the chat.
Okay.
If dispute arises after you have paid hourly fees, do you reimburse from operating account if that's how it's resolved?
So I think if you've already billed the fees and moved it to operating, and then it's disputed and they win, then I would say that you should reimburse it from operating, yes. Technically, if it's disputed, you should move the money back into trust while the dispute is resolved. And that's why it's really important to send bills out and give them 10 days to disagree with it, basically.
Great. And then back to our earlier conversation about DocuSign. This question's about your thoughts on using DocuSign or HelloSign rather than having clients sign and scan documents back to you.
So either one is acceptable to me. From a customer service standpoint and a client management standpoint, DocuSign and HelloSign are better than me having clients trying to print out documents, sign them, scan them back in, or the worst is having them take pictures of it from their carpet and trying to text me the pictures of the signed document. So from a practice management standpoint and a client management standpoint, usually DocuSign and HelloSign work better than having them print sign and scan. It depends though on the sophisticatedness of your client. I have some business owners who have full offices at home and are able to do all that, and it's fine. But for the most part, I just use the electronic signature process because it's easier for the client and easier for my staff to manage signed documents that way.
Thanks, Jen.
Mm-hmm.
Let's move on to the next section for now.
Okay, now we can answer more questions too. I think we have about 15 minutes left. So collection issues, which is the bane of most of our existences when it comes to billing and that kind of thing. Evergreen retainers are really important. And so what an evergreen retainer means, and it just like it sounds, it means you always have the green. And that means you've put money into the trust account and they're going to replenish it whenever it drops below a certain level. So for example, if I'm doing an hourly agreement and my initial retainer is $5,000 and I want them to replenish whenever it gets down to, let's say, $1,500. So like 3 hours of work left in my trust account, I want them to replenish it. Then you're not invoicing them each month for them to pay a bill. They're replenishing their retainer. So you're taking money out of your trust, paying your bill, and they're replenishing it. There's another way to do that too. You can just send them a bill and you have the money, you're being held in trust and they're just paying the ongoing bill. Either way works, as long as you're not doing more work than what you have cash for. Because what inevitably happens is we do a retainer for $5,000 and then we bill out and we have a whole bunch of stuff that gets done 1 month and we're over the $5,000. And then they don't pay, or it comes in really slowly and you're out money. And so my goal for any attorney that I work with and talk to is always have the green. It ensures timely payment if you have an evergreen retainer, and that's in the sample fee agreements as well, I believe, is how to structure an evergreen retainer. And it also allows, if you're not getting paid, for withdrawal at the first sign of a problem. Now, that's subject to professional conduct rules on withdrawal and your practice area rules on it. And I know what the federal bankruptcy rules are for withdrawal, but every practice area has their own little quirks when it comes to withdrawal. But I would encourage attorneys to withdraw if they're not getting paid. And I know that sounds cold and crass and harsh, but I think a lot of us get into this habit of continuously working on something and not getting paid and then writing it off. And I especially see it in some industries where you're always no charging things. And I encourage you not to no charge things, because we are valuable professionals that should get paid for what we do. And you have to have that attitude in order for people to pay you. Suing for fees. So it's probably never a good idea to sue for fees. And that's why I say that you should get paid ahead of time or have an evergreen retainer. There are times when I guess when you probably could sue for fees. There are potential professional liability insurance issues, because whenever you go to renew your liability insurance each year, one of the first questions they ask is, have you sued a client for fees? And not that they're going to drop you for sure, but liability companies don't like attorneys who sue for fees, because it often leads to a bar complaint or other type issues, because it's one of those, well, if you're gonna go after me, I'm gonna go after you type things. So it's really not fun to sue your own client. And that's why that arbitration clause and the state bar's arbitration program works really well, because you can avoid some of that. And also they're pretty, if you have done the work and you can document it, they're pretty pro attorney on those types of things. So they want us to get paid as well, but they want to make sure that the attorneys who are either scamming or doing bad work out there aren't able to get away with that either. So there's both sides of it. Avoiding accounts receivable. I don't like accounts receivable. I don't have any accounts receivable. So if you haven't gotten paid or you don't have money in your trust account, don't do the work. So that's practical advice. I know it's not always the easiest thing to do, but I would tend to want to avoid accounts receivable. And from an accounting standpoint, it makes your usually cash flow in the firm better by not having accounts receivable. If you do have accounts receivable and you want to try and collect on it, you can try to send it out to collections. I know there are, excuse me, I know there are some attorneys who will specialize in collections. I don't know the names of any that do specifically legal collection because most attorneys have written it off before then. But you can send it out to collections. I do know of a couple of attorneys who have an in-house person who basically their job is to call and collect. I would recommend changing your business model if you have to hire someone to come in and collect fees. And then tracking and forecasting. So if you avoid accounts receivable, it's a lot easier to track revenue and forecast revenue. I'm a big fan of forecasting out 1, 3, 5-year revenue goals. And when you have fee agreements that are either flat fee or predictable, it's easier to track and forecast going forward. Which I know it's a little controversial. I tend to be more forward-looking than backward-looking on how law firms are managed. So, okay, we have time for lots of questions now. We have 10 minutes left.
Yeah, great. Okay, we do have a lot of questions.
Yep.
The first question is, can you transfer money that was accepted in through an operating account to a trust account?
You're not supposed to. You can't. So if you do something like that, I would have good documentation. So if the amount came in was $1,000 from the client and it's supposed to be into their trust account, then make a note of it that $1,000 came in, $1,000 was put immediately into the trust account. There are some states that using PayPal is a violation for trust accounts because they take the fees out of it and you have to transfer it to an operating before it can get to trust. So if you're doing it that way for some reason, or for some reason it accidentally gets put into operating, I would make a note of it and document it so that if the bar comes and audits your trust account, you can show exactly what you did.
Great. Next question. If a solo lawyer represents a contractor under a flat fee arrangement to prep a contract that gets sent to an owner for review, and if the seller wishes to avoid the trust account requirements, is there an approved hybrid arrangement whereby if the contractor gets the job, then the flat fee for prep of the contract goes to another flat fee? Is this an example of an approved type of contingency arrangement?
So that was pretty complicated, but I believe so. Okay, so my viewpoint on fees and law practice management is almost everything can be done. So I would say there's probably a way to structure it as long as you are not violating any of the rules for written fee agreements being over $1,000. And if you're disclosing to the client what the fee agreement is, I would say there's probably a way to do it.
Okay. Next question. In litigation matters, if the lawyer is representing an entity party to the litigation on an hourly basis, is a personal guarantee from an owner of the entity enforceable?
I would say yeah. I'm not sure. I've never run across that before. So I'm a bankruptcy attorney. I recommend all businesses should get a personal guarantee from anyone, and all business owners should never sign a personal guarantee. But I would recommend getting a guarantee if you're representing a business, yes. Now you have to be careful of conflict. If the business owner's interests are different than the entity's interests, you may have an issue there.
Mm-hmm. The next set of questions are on the interest on lawyer trust accounts. Mm-hmm. Can you explain more about using that account to take a flat fee retainer?
So if you're doing a true retainer, which means, so I didn't go into what a true retainer is. Someone's reserving your time and you're going to bill them for services ongoing. The retainer can be put into your operating account. If you're doing it, you're depositing a retainer that you're going to draw from with flat fees. So, and estate planning is the easiest way to describe this one. If you have $2,000 estate plan that you're going to do, and you put it all into a trust account because you haven't done any work yet, and the fee is conditioned upon you actually doing X, Y, and Z. Usually it's drafting the documents is the first part where you earn a fee. So most estate planning agreements will say, I earn this fee of $1,000 immediately upon drafting and sending you the documents. So then you move $1,000 from trust to operating. As soon as you meet that, you've earned that fee. And then the next part of the fee agreement will say the remaining 50% will be due and payable upon signing of the documents. And so immediately upon signing, you move the money from trust to operating. So it depends on how your fee agreement is written for flat fees. My fee agreement is written that it's earned upon receipt, and here's what I'm going to do for the fee. And the magic words in there, which you really need to look at in 1.15, are the client has to be notified in writing that they have the right to demand that you put it into trust account. But by signing this agreement, they understand you're putting into operating.
Great. So question related to that. The interest on lawyer trust accounts do not have individual sub-accounts for each client. So what is the best practice to prevent the issue of mixing or blending the funds?
So that's where having good records comes in. So yes, most IOLTAs have just the one account. You don't have sub-accounts unless you're handling really big real estate or escrow transactions or something like that. So if you have one account, you need to have either a QuickBooks register with sub-accounts or a spreadsheet. It depends on how much you use your trust account. If it's being used fairly rarely, then a spreadsheet probably could work to show what fees have come in, what has been dispersed, the date of disbursement, and the reason for disbursement. So I would say QuickBooks is probably your best bet to start with that, to be able to use sub-accounts.
Will sending unpaid fees to collections require disclosure to malpractice insurance carrier?
Yes, they almost all ask that on renewal.
And can you please re-explain the process of how funds are handled when clients pay retainer versus credit card from initial deposit to operating account?
So if a client pays you with a credit card and it's going into trust because you're going to bill against it, is that the question?
If they want to type it in again and clarify the question.
Because usually the problem with credit card processing and trust accounts is you have to make sure that the processing fees are coming out of your operating account and not your trust account.
Yeah, they said yes, based on hourly billing.
Okay, so yes, based on hourly billing, the funds go into your trust account, and then whatever your fee agreement says, how often you're going to bill. If you're going to bill on the 15th and the 30th, however you're going to bill, then once you do that billing and you send it out to the client, you should move that money then from trust to operating as earned.